Number 29, the people of the state of New York versus Charo N. Allen. Counsel?
Yes, good morning, Your Honors. My name is Lauren Tan, appearing counsel to Mr. Timothy D. Cinney, District Attorney of Suffolk County, and appellant in this case. Your Honor, we are requesting 2 minutes rebuttal.
2 minutes?
Yes.
Yeah.
Your Honor, in this case, there is no hearsay defect, and here's why. The witness in this case had the supporting deposition read to her in her native language, and she swore to the truth of it, and she signed it under oath. So therefore, she has adopted essentially the factual allegations asserted in the supporting deposition. So in this situation, there is no hearsay defect at all. And the court also the trial court also erred in requesting that we have filed the witness's affidavit in her native language and a verification in her native language as part of the pleadings here, which is also is incorrect, Your Honor. As Mr. Anderson mentioned, the CPLR 2101B essentially requires all papers filed in New York State to be in English, which is what was done in this case. Now, in the event if you were to file an affidavit or an exhibit in a foreign language, then you have to provide the English translation with the affidavit translation. But in this case, every paper filed, including the accused instrument and the supporting deposition, was in English. Therefore, that statute did not apply to this case. Your Honor, furthermore, the appellate term also, I believe, incorrectly ruled that the affidavit translation is required in this case as well. As stated earlier, our supporting deposition was facially sufficient, and it provided factual allegations for the charges, and the affidavit translation is not necessary for pleading requirement. It is not something that's recognized under the CPL pleading statute. It is not a supporting deposition. It doesn't provide any factual allegations of evidentiary character. Therefore, even if the court had required it, there's really no filing mechanism for this piece of paper as well. And therefore, we believe that the appellate term's decision in affirming dismissal should be reversed because there is no hearsay defect, and the affidavit translation is not a required document to be filed for pleadings.
Counsel, on a motion to dismiss, what would constitute sufficient factual indicia that a witness didn't understand the content of her statement in order to require and prompt a hearing by the court? Give me an example. What would the allegations be?
Okay, so given that the new discovery statute we have now, we have to, as prosecutors, we have to provide contact information for the complainant or the witness. So under those circumstances, defense counsel can easily interview the witness with his own detective or investigator or interpreter and see, and have them maybe compare the supporting deposition, see if it's actually accurate and to what they actually had conveyed to the translator. So that's one way of creating factual allegations in that sense.
Thank you.
Counselor,
Yes.
Would you agree here that the hearsay defect in this did appear on the face of the accusatory instrument in Allen?
The hearsay defect?
Yes.
No, Your Honor, we don't believe there's a hearsay defect.
Okay. How about the people had their certificate of transportation? That was valid, right? But after that, didn't they subsequently have to either make a motion to amend the accusatory instrument or file a separate superseding accusatory instrument?
No, Your Honor, we disagree with the appellate term's decision that this affidavit translation wasn't filed properly because as I mentioned, the affidavit translation is not a supporting position. And under the file mechanisms provided...
Right, but isn't the argument that it affected the factual allegations?
I'm sorry.
Isn't the argument that it affected the factual allegations? So therefore, either you file a superseding accusatory instrument or you can't go forward on it because under Hardy, you can't amend the factual portion of the complaint or the information.
Oh, yes, Your Honor. The affidavit translation is not making an amendment to the factual part. There's nothing incorrect regarding the fact of the supporting opposition, as in Hardy. So that's not really on point. And also, the amendment statute, 170.35(1), it specifically asks for providing supporting documents to amend it if there's a facial defect. Like we stated, there was no facial defect in this case. And even if you were to submit additional documents, it has to be a supporting deposition or a type of supporting deposition, which is not, affidavit translation is not a supporting deposition within the definition of, I believe, 100.20. So therefore, the CPL doesn't really provide any mechanism or any mechanism at all to file something like this. The fact that we had submitted an affidavit translation in our motion papers, I believe, is sufficient enough to give the defense.
No, and let me ask one last thing. Am I right that here that the court adjourned itself and allowed the people, if they wanted to file a superseding information?
Yes, and the court's decision did allow us to file superseding.
Was one ever filed?
No, but it's not,
Why not?
Your Honor, it's because the court's decision, you can't parcel out the decision just for the superseding. Her decision specifically requests for filing of a superseding information with an affidavit in the witness's native language and a verification in her native language, and then the English translation of that document, and then the affidavit translation. So there was a lot of steps we have to comply with. So it's not as simple as just filing a superseding information. We would have done that if it's just filing a superseding information with an affidavit translation. We already have the affidavit translation, but it's all the extra documents that she's requesting us to file in furtherance for pleading, which is not required in the criminal procedure law, which is why we did not file in this case and sought leave to withdraw.
This is also an instance where the court required compliance with 2101B, wasn't it?
Yes, and we had, as I stated earlier, I believe the trial court had completely misconstrued the statute 2101B. We did comply with 2101B. In fact, that our supporting papers along with the accusatory instrument was filed in the English language, is what is required in that statute. And no affidavit or exhibit were attached to our accusatory instrument that was in a foreign language. So therefore, the court took the second part of the statute and misconstrue it and require us to file these extra foreign language documents that we do not simply have.
Your point is because here the police officer did the translation and the victim signed the affidavit, is that right?
Well, the witness had orally communicated to the officer, which then was
Right, he
transcribed.
translated it and she
Right, there
signed
was-
it. You read it to her and she signed it,
And then
right?
he read it back to her, and then she signed it under oath. There was no, I just want to make this record clear, there was no written foreign language document anywhere. It was not created, it was not generated. So for the court to request this for us, we would have to generate a specific document for pleadings, which is not required. And that's assuming this witness can actually write in her native language. Because just because you can speak a dialect doesn't mean you can actually put it in written form.
But lots of affidavits are actually written by someone else, and what the person takes an oath to is that everything in that statement is correct, right?
Yes, Your Honor, I do agree with you, but we would have the same situation. If it's not a statement written by the complainant herself, we will always have this issue about the accuracy of the translation. So the fact that the
But
witness...
shouldn't your office be worried about that? Don't you want to make sure that you have the correct statement, that it is accurate?
Well, Your Honor, the supporting document...
I mean, I would think this is not a problem because, of course, you're not going to go about the business of having someone interview a witness, a complainant, who doesn't know the language, might be saying that the person has said something which in fact they have not said, may have misunderstood an actual word that is consequential, right? I mean, I would assume you're already doing that, so it's just a matter of putting it on paper.
I'm sorry,
Well, I'm saying, I assume that your office, because you're going through this exercise, is only allowing translators to do this because they can, in fact, translate, because they have the skill set. It is a skill set.
Right.
Not everybody can do this,
Right.
right?
I-
So then all you have to do is explain the basis for their ability. That's all it is, right? But how is that a heavy lift, is what I'm saying to you?
Well, Your Honor, the officer's ability to translate was provided in the affidavit translation. He did indicate that he can speak.
What did he say?
That he understands the English and the Spanish language. I believe that's sufficient on its own.
Just merely understanding, I mean, that actually would not get you a certificate in any place that certifies people to actually do this work that we're describing, this task.
Your Honor,
I understand, I mean, I understand French. I took French in high school. No one should let me translate for someone who speaks French into English.
Well, Your Honor, I think I want to address, in this partner position that was filed with the court, the content of the factual allegations were read back to the complainant. So it's this document that's being offered to provide the factual allegations, which she had understood before she signed and sworn under oath. That alone is sufficient for pleadings. Any further inquiry as to the factual allegations really is a matter that's reserved for trial, which we have seen on many occasions where the witnesses' statements are being used as tools for cross-examination. It's routinely done. So it should not be different here just because now...
Well, it is the only kind of defect, right? It's the only defect that applies in a situation where a defendant is facing prosecution based, at least in part, by allegations from someone who doesn't speak English, correct?
Well, I don't necessarily see a defect. If the supporting documents, if the allegations in the supporting documents have been read to the complainant and she understood what she's signing, essentially she's adopting.
Well, but you're saying you could explore the problem later, and all I'm saying, it's the only kind of challenge, let me put it that way, for a defendant that exists for only this category of defendant who is facing allegations, a prosecution that's in part based on allegations by someone who doesn't speak English, right?
No, it could also be under circumstances where it's an English witness as well.
Where it's what, I'm sorry?
English literate witness as well. We've had challenges before where counsel may have interviewed the victim, whether it's a domestic violence case or not, and they're claiming that the victim now didn't say this, or that's not what she said, that's not what she meant. Those issues have been raised.
Well, not what she meant is about interpretive, not sort of the actual literal words, right? That's a little bit different, right?
Right.
I may write something and you may view that that means X when I intended it to mean Y, but the words on the paper are the words on the paper.
Right, but if you have a non-English literate witness who cannot read English, an affidavit translation is not going to cure that alleged defect because she still hasn't read the statement. And the witness in our supporting that position had that statement read to her. Providing an affidavit translation is just another statement saying it was translated, which already was said in our supporting that position. So if the real issue has to do whether or not the complainant actually understood what she had signed her name under oath, which carries criminal liabilities should this instrument be false, an affidavit translation is not going to cure that. However, as Mr. Anderson did mention earlier, the court could require the complainant come into court and do a verification in court to ask her or him, this part of the position where you read the statement, do you understand it? Is this your signature? Are you swearing under oath? That way, if there's a legitimate concern as to...
You think that makes more sense than just having the affidavit in the language where she's swearing, right? In her own language. You think that that's the better process? You think
To
that...
have the affidavit translate, I'm sorry.
Well, to do what 2101B seems to address in the civil context.
Right, so you're asking me, should we
The
have...
affidavit is generated in the language of the person who's signing it,
Okay, I don't think there's a
as
requirement.
opposed to calling people into court and having them say what they could have said on a piece of paper in their own language.
Right, but
Yeah, I
there,
mean, you're going to translate either way, right? She's got to translate in court, you're going to translate it on paper, same thing.
right, but there is no requirement in a CPL for a
Okay, so
foreign
that's the
language
core
document.
argument, which I understand.
Right.
Okay.
But
Thank
there-
you, counsel.
Yes.
Thank you. Counsel?
Good afternoon. May it please the court, Felice Milani for the respondent, Ms. Allen. May I proceed?
You may.
In 1987, this court decided People v. Alejandro, relying on the natural meaning of both CPL 140 and 115. I would suggest that by affirming this case, we would continue to be relying on the natural and obvious meaning of CPL 140 and 115. To comply with these statutes in Ms. Allen's case, for sufficient information, for menacing in this case, every element must be established by non-hearsay allegations. The prosecutors in these cases, the appellants, continue to assert that merely using a translator does not make the statement hearsay. But how do we know that every element is correctly stated and alleged by the complainant? Can we defend, as a defendant, can we defend our clients against the right crime with confidence? This goes to the core fundamental rights that all of our clients face, especially in misdemeanor cases where they're not presented to a grand jury to verify. I believe one of the respondents, or one of the prosecutors in this case, mentioned having preliminary hearings. Well, they don't do that here. So we have these verification requirements for a reason. As this court has often stated, and recently during the arguments in Hardy, the requirements require that there be reasonable cause to believe that a crime was committed on a certain date. We're bringing people into court arrested for misdemeanor offenses which could possibly result in a year in jail on less than verified accusations. How is that constitutional, and how is that supportive of their due process rights?
Counsel, up here, sorry. It's a different scenario, but how is that different than what happened in Edward B? I mean, I understand there are certain different facts in this case, but generally, how is it different than Edward B? Because that's a hearsay problem. That's a case where the complaining witness clearly never read the affirmation, and we said it isn't a facial defect. So if we go with your broad-based, very well-articulated position, wouldn't we really have to be overruling that case? Because it doesn't really matter what the hearsay problem is, and we'll accept for a moment this is hearsay under your view, but isn't that the same problem that we had in Edward B, and we put a footnote in there saying this isn't a good practice because it does what you're saying, but still we didn't dismiss the information?
Well, Your Honor, if I'm not mistaken, in Edward B, the defect became apparent at trial or soon before trial, right? There was never a motion made. The prosecutor did not reveal it, I think, until the witness was right on the stand.
That is a
which
procedural
pardon me?
difference. That's a procedural difference in your case. It's not a difference between the underlying problem that you've described, which is somebody could go and be charged in a misdemeanor where they didn't read the complaint or it was in a different language. I mean, that's the same problem. It's just a procedural timing of when you make the objection.
I agree with you, Your Honor, but that was in 1992, and now in 2021, we have all sorts of new protections for clients who are arrested for criminal cases.
Are you asking us to overrule Edward B?
No, Your Honor, because I believe that it is a different situation in conjunction with the new discovery requirements, if that makes any sense. And specifically in our case here, this was apparent from the face of the four corners of the instrument. But now, and I believe, even though it wasn't mentioned in any of the briefs, my adversary did raise the discovery requirements. And I would suggest, as an answer to one of, I believe, Judge Fahey's question earlier, what do we rely on? Well, we rely on the new discovery requirements. We rely on 3035A, which now requires that the people say that they have supported each and every allegation with non-hearsay allegations or documents. So I agree that Edward B. could be interpreted differently. However, it also recognizes how procedurally defective something can be if someone isn't aware of the accusations against them. And to have to go to court, let's say that someone does go to
Counsel, can I
trial and
interrupt
is
you?
facing...
Counsel, this is Judge Stein. I'm having a little difficulty understanding, is it your argument that it's hearsay, or is it your argument that someone can't read a statement, can't verify to its truth? Because,
Well-
let me just add to that a little bit, because it seems to me that in matter of Edward B., the court emphasized that the complainant had neither read it nor had it read to her. So, so that's not, that's not the case here. So I don't understand why we're calling this hearsay, as opposed to whether she can state, verify its truth.
That would be my distinction then, I guess. If that makes sense, maybe that would be a better answer for Judge Rivera, because this goes to the heart of these facts. It goes to the complainant's ability to verify the actual charges and allegations that she's bringing forward.
Okay, but then would it be impossible for someone who's illiterate, who can't read or write, to ever verify a statement?
Well, what I will say is this, and I know that the prosecutor in their argument did bring that up, that this presupposes that non-English literate witnesses can read and write. Well, no, it doesn't. But the burden is on the prosecution, which in this case is through the police officers, to bring forth a valid case supported by valid accusations. And the normal practice, from where I see everywhere, is to have these police officers write down statements for anyone. So it's their job to correctly allege each instrument of the crime and take down a witness's accurate statement. So if someone is blind or deaf, you would think that, yes, they would need to have those translated or read. And if someone is illiterate, well, you know what? You'll have a
But isn't
fluent
that exactly
English
what-
police officer reading those
Counsel-
words to them.
Counsel-
And you can be confident that, I'm sorry.
Isn't that exactly what they said they did here? You're just questioning how they have to demonstrate that and when that has to take place and whose responsibility it is. And, it seems to me you're talking about the new discovery rules, that if you're going to be getting this information that much more quickly, it gives you every opportunity to pursue any questions you may have about its validity, which it seems to me would be the purpose.
Well, in this case, it wasn't done exactly and it wasn't done correctly, and all arguments were preserved in the initial motion that the defense counsel made and then in their reply motion. The written translation here was used to support the accusatory instrument. And if you'll notice, the translation was made by an officer who was not the officer who signed the original complaint. So there's a load of problems here. And I know this court also asked several people about CPLR 2101 and how that could be applicable as other than the language where it stems from that new NYCRR 200.3. Well, they have to be non-hearsay allegations, right? And when you look at all the hearsay exceptions, those are listed in the CPLR. So it's not something that would be too big of a leap to require that to make this document a non-hearsay document and sufficient, that you go to the CPLR and you go to CPLR 2101. But
Counsel, can I
regardless,
just,
in this case...
Counsel?
Sorry, go ahead.
That's sorry, this is Judge Rivera. I just want to clarify something. The statement that's made by the officers that they read what? What did they read to her? What did they read?
Well, they read they allege to have read, it says in the supporting
Yeah, go ahead.
document that they had the statement consisting of one page, which is this, I'm giving this statement freely, it's the standard supporting deposition. I could read it all, but I
No,
think
no,
it's in
no,
the
I just-
record, and I don't
okay.
think you'd like
But
me to
it-
read the whole thing.
But just to clarify, what that means in the record is that they could not really have read the statement because it's in English, correct?
Correct,
So
correct.
it's not really that they read the statement.
No,
that
so
they
what,
have
what the officer
provided
wrote
the
a
translation of the
translation.
statement.
I mean, the Spanish-speaking
Yes.
complainant spoke in Spanish
Yes.
to an individual named Officer Morin.
Yes.
Then that officer allegedly translated that Spanish oral statement to an English written statement.
Okay.
Okay, after writing the statement in English, that officer then supposedly read the English version, not a Spanish version, an English written version, and translated back into Spanish.
And did
then
did
a
any,
different
and
officer
did the
signed the
officer
complaint.
aver that they read the verification also?
Read the verification, is it, I mean, it says I have had the statement consisting of one page read to me in Spanish by Police Officer Marin, and I swear that this is the truth. So
But-
I'm
but is
assuming
there
that he read
anything there
this
that
in
says?
Spanish.
Yeah, but is there anything there that says they read the verification also?
No, there is not.
Okay.
And also, it says in the translation that he understands English and Spanish, but as this, I believe Judge Rivera, you pointed out, that is not enough. I mean, I also understand Spanish, so, but I'm not fluent, and I think the requirements say that you need to be fluent. Regardless, this matter could have been cured, but the prosecution simply chose not to follow the law in CPL 17035A.
Thank you, counsel. Thank you, counsel.
Thank you very much.
You're welcome. Counsel?
Yes, Your Honor, I just want to follow up that the supporting deposition, the entire one page was read to the witness. It's under assumption that the false statements filed herein, that provision was read to her too. But if there really was an issue with the verification, as I stated, the court could ask the complainant to come into court and verify her on that.
Well, why is that? Why isn't that then within the four corners?
I'm
Why do we
sorry.
need to do that? I mean, if the whole argument is the CPL only allows you to look at the four corners, CPL has particular rules, our case law is very clear, we're looking at the four corners, we're not going beyond them, you look at the four corners, and you say, where does it say that she was informed of the penalty and there's a verification? Where is that?
Your Honor, the supporting deposition itself do not specifically have those language, but if you read within the four corners of this document, where it says this statement consisting of one page, this one page has the verification part in there.
Is your
So-
position then that the statement is not separate from the verification, it's all one thing?
Yes, when it says it's one-page document, it didn't say I just read the statement only, it's the one-page document, which includes everything on this one page. It shouldn't be dissected like in segments this way. It should be, like you said, it should be read within four corners of this instrument.
Thank you, counsel.
Yes.
Thank you.